Hello everyone, I am Barrister Mohammad Fariduddin and welcome to the Constitutional Law Lecture. I have ended my last video clip with the discussion of conventions, and I will continue that discussion in this video clip as well. You know from the last video clip that Evidice distinguished laws from conventions. The former he defined as comprising in the strictest sense laws such as statute, judgment law, and common law doctrines which are enforceable by the courts. The latter, that is to say, conventions, are really understandings, habits, and practices which are not enforced by the courts, but which still regulate the conduct of the members of the sovereign power. Dicey's view about conventions appear to have been influenced by John Austin, who himself distinguished non-legal rules from legal rules. And he also believed in the general value of rules made for the guidance of man or woman, together, the mankind or womankind. Conventions do not appear to fit within Austin's definition of law, as no clear sanction or enforcement accompanies any breach of a convention. However, they do fit in with the idea of morality. Dicey followed this analysis when describing conventions as the morality of the convention. Most courts appear to follow Dicey's distinction that conventions may be recognized but not enforced. The courts in the United Kingdom rarely used a convention as an enforceable rule. For example, in Majjibamuto versus Lardner-Burke, the Privy Council had to consider a convention contained in a 1961 declaration that the Westminster Parliament was not to legislate for Southern Rhodesia. Lord Reed commented that the convention, although important, had no legal effect in limiting the legal power of the Parliament. Another example is that of Attorney General versus Jonathan Cape Limited, decided in 1976. Here, the case involved the recognition of the important convention of collective ministerial responsibility. After death of Richard Crossman, who was a labor minister from 1964 to 1970, his executors published the daily political diaries of Richard Crossman in Sunday Times. The Attorney General argued that collective cabinet responsibility provided a fundamental requirement of cabinet secrecy, which should be enforced through an injunction. The court recognized the existence and importance of the convention and the constitutional obligation it imposed. But publication could not be prevented simply on the basis that it breached such a convention, as the courts had no powers to enforce conventions. Similarly, in reference re-amendment of the Constitution of Canada, 1982, the Supreme Court of Canada, in a lengthy consideration of the relationship between law and convention, also recognized the existence of conventions, but also confirmed that the courts are unable to enforce them. The court nonetheless highlighted the constitutional importance of conventions. It said that it should be borne in mind, however, that while they are not laws, some conventions may be more important than some laws. Their importance depends on that of the value or principle which they are meant to safeguard. Also, they form an integral part of the Constitution, and the constitutional system, constitutional conventions plus constitutional law equal the total constitution of the country. You should bear in mind, though, that not all practices are conventions. So how can you distinguish normal practices from conventions? Jennings suggested a practical test for establishing whether a particular convention exists. He gave 3 requirements. First, are there any precedents? Second, did the actors in the precedents believe that they were bound by a rule? And finally, is there a reason for the rule? In many situations, this test clearly determines that a convention exists. For instance, it is a convention that the monarch does not refuse to give royal assent to a bill passed by the parliament. There are many precedents, and the monarch apparently believes that she is bound by this rule. There are also good democratic reasons for that convention. However, in other cases, the existence of a convention may be less certain. For instance, is it a convention that a minister who has engaged in a discreditable sexual relationship should resign from the government? An example of practice that would not be regarded as convention is that ministers' official papers are transported in a special red leather covered boxes. This has happened since the 19th century. In 2015, the Prime Minister decided to abandon the practice of red box. He did not think himself bound by the practice, and apparently there was no good reason for the practice.